Hi. So how to get an anticipatory bail in an SCST case? The topic is more important because for any crime under Indian Penal Code or any other law, but I'm only limiting my argument only to the Indian Penal Code, you get anticipatory bail. But SCST case, coupled with the penal provisions in Indian Penal Code, you don't get an anticipatory bail because it is clearly written in the SCST Prevention of Atrocities Act that anticipatory bail must not be given. So therefore the topic becomes important right now. Now, before understanding the topic in the video, we must understand what is the difference between a regular bail and what is the difference and an anticipatory bail. Regular bail is taken after getting arrested. Anticipatory bail is taken before getting arrested. So in anticipation of getting arrested, anticipatory bail is taken. So when anticipatory bail is taken, whenever you come to know that there is an FIR against you, you immediately approach a sessions court or high court and obtain an anticipatory bail. You apply for that. But here, when law itself clearly said that anticipatory bail is not permissible in an SCST case, some complainant could take advantage of this provision. So therefore, Supreme Court settled this issue, this question, by giving a decision saying that anticipatory bail can be given even in an SCST case provided there is no prima facie case. So what is a prima facie case? So before understanding what is a prima facie case, we should understand when anticipatory bail is taken. Anticipatory bail is taken at an FIR stage. So in a criminal trial, first FIR is registered, then remand report, somebody is arrested and remand report is presented before the court, then charge sheet is presented, then trial, then punishment. So these are the 5 basic steps. But anticipatory bail is applied at an FIR stage. Okay, that's a preliminary fundamental primary stage. So when anticipatory bail is applied, what is the material that is available before the court? Only FIR is available before the court and the ingredients of the FIR. So from the ingredients of the FIR, you have to know that prima facie case doesn't exist. Now coming to what is a prima facie case? It is case at first sight. Like love at first sight, it is a case at first sight. If there is no case at first sight, then it means there is no prima facie case. Then anticipatory bail can be granted. So how to know that there is no case at first sight? On the face of it, on the face of FIR, there is no case. I will better illustrate it with an example. One of the common allegations for an SCST case is that the SCST member was humiliated or intimidated or foul-mouthed in a public space. So that is a common allegation filed by an SCST member against a non-SCST member. So abusing him by using his caste. Now, the fundamental of this allegation is that it should be in a public view. Now, if the complaint itself, the ingredients of the complaint itself clearly shows that it is not in a public view, it is in a private view, in a closed room, in a house or in a room where only the complainant and the accused are available. If the complainant drafts that in the complaint, now it doesn't attract the ingredients of the provision. So on the face of it, on the prima facie, it appears there is no case because the ingredients of the provision are not attracted. Then you get an anticipatory bail. So this is what Supreme Court decided, that if there is no prima facie case, then you get a bail, anticipatory bail. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.